Hello class, good morning, good afternoon, or good evening whenever you're watching this video. So we're up to chapter 13 now. I hope everything is working well for you with regard to the videos. If not, please let me know. Chapter 13 has to do with contract performance, breach, and remedies. So this is a situation where we have a contract or we've got a problem with the contract, and how are we going to deal with it. So the first thing to keep in mind is, what is a remedy? We've talked about this before, but a remedy is basically what the person who's been harmed can get as a result of the harm. So it's the relief provided to an innocent party when the other party has breached the contract. It's the means employed to enforce a right or redress an injury. As we talked about before, remedies can involve damages. In a contract situation, it can be rescission, which means to do away with the contract. Restitution, which means provide somebody with something, usually money, to put them in the place where they should be. Specific performance, which is ordering a party to do something. And reformation, which means to change the contract to make it fair or comply more with the law. Okay. So, what kinds of things can prevent enforceability of a contract? Well, one of those things is a lack of consent. That is assent to the contract. And even though you may think that you have a situation with an agreement between the parties, there can be things that make the consent to the agreement lacking. So what are some of these things? First of all, we have mistake. Second, we have fraudulent misrepresentation, undue influence, and duress. Mistakes involve mistakes of fact and mistakes of law. Okay? Only a mistake of fact can make a contract voidable. And that occurs when the parties entered into a contract with different understandings of one or more material facts relating to the contract's performance. They can occur in two situations: a bilateral mistake or a unilateral mistake. So for example, if you go to buy a car and the year model of the car is important, and the parties, either one or both of them, are mistaken as to the year model of the car, that can be a mistake of fact. So a unilateral mistake of fact is a mistake. My dog just walked past here. I don't think you could see him. Astro, get out of the way. A unilateral mistake is one that's made by only one of the parties, and generally does not give that party the right to relief from the contract. The contract is usually enforceable except in two exceptions. Okay? And this has to be a material fact. What does a material fact mean? A material fact means that had the person known of the mistake, they wouldn't have entered into the contract. Anything else would not void or make the contract voidable because it's not material to the outcome of the contract. So, for example, I once bought a car and the color of the car listed on the was told to me to be white when I bought it. It looked white. When I went to sign the contract, in the description of the car, it had something, some other color, like an off-white color. That's not a material fact in that situation. The error itself has to be due to an inadvertent, substantial mathematical mistake and not gross, extreme negligence. That can be another type of factual error. A bilateral mistake occurs when the mistake is made by both contracting parties about, again, a material fact. This does not compel either party to rescind but may entitle a party to rescind. So when we have a bilateral mutual mistake of fact, either party can rescind the contract when both parties are mistaken. In a situation where both parties reasonably interpret a term differently that goes to a fact, then the court can allow rescission by either party. Now, what about a mistake that's not of fact but of value? What something is worth, or the quality of something? What quality is it? Contracts cannot be rescinded due to mistakes of value. Each party is considered to be assuming the risk that the value might change in the future or prove to be different than what they thought the value was going to be. So your mistake as to the value of something, for example, if you buy a watch from an individual and you think that that watch is worth $500, but it turns out to be only worth $200, that is not the kind of mistake that will lend to or lead to rescission or invalidation of the contract. Now, when a person is misled into entering into a contract based upon the misrepresentation of a fact, that can be grounds for rescission. The innocent party can rescind the contract or enforce the contract and seek damages for the harm resulting from the fraud. So in order to have fraud, you have to have these elements. There has to be a misrepresentation of a material fact. There must be an intent to deceive, and the relying party has to justifiably rely upon that misrepresentation. And there has to be some harm to the person in order to collect damages. The example I like to give a lot of times with regard to these types of mistakes is the sale and purchase of a Ford Mustang. Forgot the word for a minute. The Ford Mustang was first produced in 1964 or 65. I've been corrected by students because apparently the first model came out something like 65, but it was actually came out in 64. Doesn't matter for the purposes of this example. The point is, though, if you were now to buy the first year model of a Mustang, it would be worth a whole lot more than any subsequent year because it's a classic car. Okay? So if you went to buy one now and you were led to believe that it was an original and it wasn't, that would be a mistake of fact. If the person selling you the car knows that they're misrepresenting the model, year, and that it's not a classic, then that would be a fraudulent misrepresentation. Okay? Alright. So the misrepresentation can be either by words or by conduct. What about statements of opinion? Generally, statements of opinion are not subject to an exception making the contract voidable. In other words, they're not subject to claims of fraud. Okay, so if a used car salesman tells you that the car you're looking at is the best conditioned car he's ever had on the lot, okay, that's an opinion. Okay, so that does not give rise to a fraudulent misrepresentation. If the car ends up having a lot of problems, that would not have indicated it was the best car he's ever had on the lot. An exception to this is if you have a naive purchaser relying on the opinion of an expert. Okay, then the innocent party may be entitled to rescission or reformation of the contract. Reformation meaning